Hi, this is Andrea Kane, and I'm here with you for HIT 421 Legal Affairs, Release of Information, HIPAA, and all good stuff. We are now on week 3. We are talking about this week chapter 5, which is on evidence. If you are looking at your syllabus, you will see we will be focusing on unit objectives 9.2.1 through 9.2.15. So let's get started. If you pull out your textbook, I'm on page 75. Evidence is the mean by which the facts of a case are proved or disproved. Evidence can be oral testimony, it can be contained in written documents, or it can be presented through pictures, photographs, objects, videos, all sorts of things like that. Federal and state laws govern the admission of evidence during litigation. They basically tell you what is admissible, what isn't, what types of evidence can be submitted and accepted. And they talk here about the federal rules of evidence, and then there are state laws usually that are similar also to federal rules of evidence. So let's talk about health information as evidence. It can be used to prove injuries or crime when it comes to personal injury cases, medical malpractice, such as establishing standard of care or establishing that the standard of care unfortunately was not met, workers' compensation, disability claims, custody issues, mental competence, criminal proceedings. For instance, if someone's brought in after a shooting or some type of a knife injury, that type of thing. White collar crime, which would include fraud and abuse. Health information, and before I go too much further here, I'm going to stop here and point out, if I've not said this before, well, then this is the first time, but if I've said it before, I apologize in advance, but I'm really trying to make sure you understand this. Medical records are business records. Medical records belong to the healthcare organization or the provider. They are owned by that entity. However, the information within those medical records belongs to the patient. So the record itself can never be surrendered to the patient. A copy of the information can be provided, but the original record must be maintained and held by the organization, by the business owner. But the information that is contained within that record belongs to the patient, and the patient does have some rights as to how that is handled, how it is disclosed, and those types of things. All right, so types of evidence, there's direct evidence, there's demonstrative, there's documentary, and there's circumstantial. And I think that these definitions make a lot of sense. They're pretty obvious, and you can read through them. So I'm not going to go through them in a whole lot of detail. They're also on pages 76 and 77 in your book. And on the top of page 77 in figure 5.1, it gives you some examples of cases illustrating the use of health records as evidence. Evidentiary rules are governed by state and federal rules. We've already talked about admissibility. I've mentioned hearsay. Hearsay is when somebody says they overheard something. They weren't the person who said it. They may not have been there in person, but somebody else who was there in person told them. That's hearsay. Business records, there is an exception, a business records exception. And let's see, do they cover that in your book? I hope they do. Oh, they have a section on that. Yes, they do. Page 80. Because health records consist of out-of-court statements that are often used in court to prove the truth of the claim, they technically constitute hearsay. Notice that. Health records technically constitute hearsay. However, a major exception to the prohibition against using hearsay as evidence is the business records exception. Under this rule, a record of an act, event, condition, opinion, or diagnosis in any form, memo, report, or data compilation is not hearsay if it meets the following requirements. Medical records fall under business records exceptions. as long as these exceptions are met, or these requirements are met for the exception. And this is why you will hear health information management professionals say over and over again, documentation must be done at or near the time of event. It has to be by a person who has knowledge. It has to be kept in the course of regularly conducted activity of the business, organization, occupation, or calling, whether or not for profit. The making of the record was the regular practice of that business activity. All of these conditions are shown by the testimony of the custodian or other qualified witness, or by a certification that complies, and then they give you the rule number, or with statute permitting certification. This is why I talked about, I think it was last week when we were talking through the legal system and legal proceedings. This is why when I was responding to court orders or subpoenas, that I had to obtain a copy of the records, and then I did the certification that was notarized. When I have been deposed, these questions right here have been asked of me every single time. Every time I've appeared before a judge in court, every time I've been deposed, every time I have been questioned by an attorney, not from the hospital side of things, but from the attorney who was asking for the records to be admitted as admissible into the court, I have been asked those questions. The other requirement is that the opponent does not show that the source of information or the method or the circumstances of the preparation indicate a lack of trustworthiness. Remember, if you are a records custodian, you have got to prove trustworthiness. And how do you do that? You show that you have policies and procedures and that you follow them. You show that these records were made in the course of business and that these are done consistently. They were made at or near the time of event from information transmitted by a person with knowledge. It's all right here. If you take nothing else out of this chapter, please make sure the business records exception section here on the bottom of page 80 that you are so very familiar with that, because you will need it if you ever go into release of information. Not to say the rest of it is not important, because it is. You need to study it for your quiz, but in the real world, that section right there is what your integrity as a health information professional will rest on if you are ever a records custodian. Then they talk about the best evidence rule and privilege. There are certain types of information that are privileged, meaning that they cannot be forced to be revealed. They are secret. There are very, very, very limited circumstances that they can be revealed. Some examples they give you are physician-patient. When a patient trusts a physician and they share something with them, that information is privileged. The physician is not supposed to share it. The patient's not supposed to share it. It stays between the two and it's not discoverable or admissible. Clergy parishioner. My husband happens to be a pastor, and we laughed about this back when we met, that we both were so used to privilege, because what he talks about, he can't talk about. And things that I ran into at work, I couldn't talk about. So we laughed that we could never really ever talk about what we did because so much of it was privileged. Psychologist and client, that is another one. Attorney-client, you may have heard of attorney-client privilege. If you are speaking with an attorney and they are representing you, whatever you say to that attorney, for the most part, is protected under privilege, and they can't be forced to disclose it. Another relationship is husband-wife. If I share something with my husband or he shares something with me, it's privileged. Neither one of us should be talking about it ever, and we can't be forced under law to divulge that information unless there's something really significant there that the judge feels may play a role in that. And that's where we'll be talking about, I think, in this class, about a case where a patient confided in a psychiatrist about, I can't remember if it was suicide or homicide, and the psychologist did not reported and something bad occurred. And you can imagine how awful the psychiatrist felt, but they, at that time, they felt that they had honored the patient's privilege. And legally, that became a precedent case where they said that if someone's going to hurt themselves or hurt someone else, you have to break that privilege and come forward. So there are those special circumstances, but for the most part, those relationships are sacrosanct, meaning that they can't be broken, that you can't force a wife to testify against her husband, a husband to testify against a wife, clergy against parishioner, and those types of things. All right, so admissibility, we've talked about that before. It has to be relevant. It has to be authenticated in order to be admitted into law. And how do you authenticate it? You have the records custodian's affidavit. That's my certification, my affidavit, that I'm documenting all of those things in my certification, in my affidavit, and then it's notarized, validating that I am the individual. I did swear to it in front of someone, and I did produce documentation to prove my identity. It is challenging to authenticate ESI because you have to describe how an electronic system monitors and manages modifications or different versions of electronic documents, and they may try and get you to show, for instance, if there have been modifications, what each version of that document was. So, for example, if you have a discharge summary and you have a doctor who went in and made changes after the fact or added additional information, can you provide a copy of every single version of that document? And can you show each time it was modified, who modified it, and how they modified it? That's what you have to be able to do, whether you're talking a paper world or electronic world. Hearsay. We talked a little bit about this. This is an out-of-court statement introduced into a court proceeding to prove the truth of the facts that are asserted in the statement. It's generally not admissible because the maker of the statement can't be cross-examined at the time the statement was made. Health records are considered hearsay, but again, there's the business records exception as long as you can meet those requirements. So hearsay exceptions when it's admissible if you have spontaneous exclamations, dying declarations, business records, which is what health information falls into, statements made for medical diagnoses or treatments. And again, they may be admissible if there's reason for the statement to be deemed truthful. And then we went through the business records exception, so I'm not going to go through it again. Except I am going to pause for a moment and say, I can't tell you how many times I've had providers in my career say to me, why does it matter if I get my records done on time? Why does it matter to you or to anybody else whether I complete this right, within a couple of days or a couple of weeks? Why can't I just, why does this even matter? And I have to go back to business records exception. It has to be made at or near the time of the event. And it can't just be from anybody. It has to be someone who was a person of knowledge, who was directly involved. So it's going back and really trying to help providers understand we're not trying to make their lives difficult. We're trying to make sure that we maintain the credibility and trustworthiness of our business records to defend us. Because I have been in situations where I have been in court, and this was back in the day of paper records, and literally, this was in Florida, which was a very litigious state. It still is in many ways, but when I was there, it was amazingly litigious. But anyway, I went into court, and I had my copy of my records and all of that, and I did my thing. But I noticed they had taken sections of this physician's documentation from progress notes and other documents that were handwritten, like orders, and they had blown them up to show how illegible they were. And it happens. All right, so hearsay exceptions. We talked about this. Exceptions also include births, fetal deaths, or marriages, if the report was made to a public office pursuant to the requirement of law, and that's where they're talking about vital statistics. They are also exceptions to the hearsay rule. Best evidence rule, you have to have the original to be produced. In our day and age, the original is electronic. And so it makes it a little more challenging than back in the day when you hauled into a courtroom thick inches of files with paper, documents, and all sorts of things. And you've got to be able to do recordings and photographs and all sorts of other stuff. Thankfully, with ESI, you can do printouts or an output that's readable by sight. And as long as it reflects the data accurately, that's going to constitute an original. And if the original, whether it's paper or electronic, is lost or unavailable, you can provide a copy. This happened to me one time with a case. We were microfilming records. This was back before we went full EHR. And we were microfilming records. And we had space constraints. And we ended up microfilming records earlier than what we had planned because of space constraints. And one of the records that we microfilmed and that we validated we had good copies of and shredded the original ended up going to be a lawsuit. And at the time, the rule was 7 years that you had for adults, you had within 7 years of the situation to file a lawsuit. Well, I think we were at the 4 or 5, maybe even 6 year mark, maybe 5 or 6 year mark, because we were getting up close to the 7 year mark. And I remember the plaintiff's attorney really giving me a hard time about the fact that we did not have the original paper documents, that they had been shredded by the microfilming company once we had approved the microfilm. And I remember coming back and saying, but we have a copy and we have followed our protocols for record retention and storage and all of that. And of course, the plaintiff's attorney was just being difficult. Unfortunately, the patient was as well, and in representing the family, he was simply kind of channeling their personality in some ways. But, we were able to say, no, we can provide you a copy. It comes from microfilm, which was photographs of the originals, but no, we can't provide the originals. Those were destroyed in the appropriate process that we were following. So we had something that was admissible. We had the copy that was admissible. It wasn't lost. It just was unavailable. It had been destroyed. But we had a copy. That's the thing. If you don't have a copy and you've destroyed it, you are in so much trouble. It's not even funny. All right, so privilege, we talked about that. That's the sharing between the two parties. So I'm not going to go over that. It has to be protected. That's a concept of fiduciary duty. That's where a person or business who has the power and obligation to act for another individual under the circumstances of trust and confidence has responsibility to protect this individual. To not protect is a breach of their fiduciary duty. So a physician patient, the physician is the one with a fiduciary duty. Clergy, parishioner, it's the clergy with a fiduciary duty. Psychologist client, it's the psychologist with that fiduciary duty. And it's a tool for protecting patient privacy in the context of litigation. It exists as a statute in most states. The patient or their legally authorized representative is the holder of that privilege and has to assert that privilege in order to prevent the medical information from being disclosed in court. And there are exceptions to the patient-physician privilege. One of those exceptions is waiver. When a patient waives their privilege, they're saying it's okay to release my information. Other waivers are related to public interest. For instance, if someone is pulled over for driving under the influence or driving under intoxication, the blood alcohol tests. A patient might not want their blood alcohol level released to law enforcement, but that privilege is waived because of public interest. And the same thing with determination of mental competence. There are some things called apology statutes. These protect communications made by providers to patients and possibly some patients' relatives from being admissible in court as evidence. This is when something happens to the patient and the doctor comes back to the patient and or family and says, you know what, we've had a medical error occur and here's what's happened and I'm really sorry. Whether it was the physician's responsibility, whether it was the hospital or the nurse's responsibility, what have you, whatever kind of medical error it is, some providers are protected when they are open and honest with patients and their families about medical errors. Protection of evidence. The organization has a legal duty to preserve information relative to potential litigation and to watch for litigation triggers. This is very important when it comes to HIM people. This is one of the biggest responsibilities we have because we see it all. We see the documentation, we see the patients and attorneys requesting their records. We see stuff through coding, we see stuff through record completion, all sorts of things. And so we are one of the first places that can alert quality management, legal, risk management, corporate compliance, patient safety, infection control, all sorts of people and say, hey, we've noticed this. I can't tell you how many emails I've sent over my career for this. It was one of the things I felt very responsible for, and I can't tell you the number of times it was the first time a senior leader heard about it was it came through my email, and it alerted them to be watching for an incident report or that they needed to start an investigation. Same thing with quality management. Maybe it identified a case they needed to send out for peer review. You definitely need to rely on your legal counsel at your organization and any organizational policies when it comes to preserving information. Record retention, better to err on the side of hanging on to things than not, because you will have to defend yourself if you don't. And it could really cost the organization. The organization may not have done anything wrong, but your failure to preserve the information may cause them to lose the case and end up having to make a huge settlement payment. Never happened to me, but I know that it is possible if that information is inadvertently destroyed. Legal hold. Oh, mercy. I had a legal file. I've always had a legal file in all the organizations that I've worked in when I've been in HIM. Some cases we ended up having the legal hold file in with legal counsel, depending on what stage of activity was going on with the record or if we were concerned about access. Usually I kept them in a locked file within my office, and there were very few people who knew how to access those. We did keep a list of what was in there, but again, we limited who had access. They had to document every time they accessed it, what they did when they accessed it, and all of that. It's essentially a preservation order, preservation notice, or litigation hold. It can be issued by the court. I never ever had one issued by the court because I had my own. Anytime we suspected there was going to be legal activity, we immediately secured the records. We took them out of the file area, or we worked with IT to put some kind of special access limit on the records, especially, not specifically, especially if the patient had expired and there was no reason for anyone else to be going into that record. But the court can do that as well. If there's concern that the information may be destroyed, they may issue a legal hold on it, or a litigation hold, or preservation notice. But I think it's really sad. This is my personal opinion. I think it's incredibly sad that the court would have to do that, and that the business or the organization would not have the integrity to do that themselves. Intentional destruction, mutilation, alteration, or concealment of evidence relevant to a legal proceeding is spoliation. Spoliation. And interestingly enough, I've been watching a show on TV about archaeology, and it has the same definition if an old archaeology excavation destroyed, mutilated, or altered or concealed the archaeology in the ground, so that when the next set of archaeologists came afterwards, they had a very difficult, almost impossible time accessing it because of that. So I find it interesting that spoliation is used in multiple venues, not just in a legal sense or in a medical record sense, but also in an archaeology sense. So that aside, it is a legal concept applicable to both paper and electronic records. It is a doctrine that drives the duty to preserve documents in the context of litigation and pending federal and state agency investigations. And I will again say, no one with any integrity ever does this. Ever. No matter what is in that documentation, you never, ever intentionally destroy, mutilate, alter, or conceal evidence. Ever. That is on your shoulders as an HIM professional. And if you are ever a records custodian, never should it ever happen on your watch. You should take every possible step to protect all information, most especially that could have a potential legal involvement. So they give us some cases to consider. And I think you can look at this in your book. It's on page 87 into page 88. And you can go through and read about all of those. How do you prevent it in EHRs? Well, you use the same standards for paper records. You use software that recovers whatever was deleted. You have policies and procedures for making changes and corrections, and you audit. You have audit trails in place to find out who's doing what, when, where, how, and you review those on a regular basis. Auditing is one of the least fun aspects of health information, I would say. It gets old very quickly, but it's one of those things that if you don't do it, you will have cause to regret it down the road, because when you audit on a regular basis, you find things when they're still small, when they're still fixable, when they're still identifiable, and then you don't find yourself 6 months, a year, 2 years down the road with an absolute disaster on your hands just simply because you didn't audit. So that's my soapbox on that topic. Retention and destruction of health information. Make sure you know your state's rules. Each state varies, so you have to know what their rules are for record retention as well as destruction. You need to have knowledge of where the information is stored, how long it's kept, when it may be destroyed, whether it's in paper or electronic form. How do you make sure that you address digital preservation when you're changing media or systems? What is the provider's legal health record? You have to define what elements are in there and establish routine practices for retention and destruction. And you have to make sure that it's appropriately done. If you contract this service out, you are responsible for making sure they follow the letter of the contract and they do it appropriately, that it doesn't end up in a dumpster somewhere, or it isn't left on hard drives, or it isn't left in a copier. I have heard of situations where copiers were swapped out of HIM departments, and they had all sorts of PHI stored in them that was used for faxing or was just recorded when it was faxed and kept in the memory long enough. Some copiers will hold on to something for a week, so if you need to go back for it and resend it, you can. And none of that was wiped out when the copier was removed from the department. And so when the copier was replaced in another business somewhere, someone was able to access that PHI. Even something as simple as a copier, you have to be so careful about. You have to really think about everything that we use and we touch these days. If you use tablets, if you use laptops, if you use cell phones, all those types of things. How are you making sure that PHI is protected and retained and then appropriately destroyed? Disaster recovery and business continuity. We here in Iowa, after last August derecho storms, learned about disaster recovery and business continuity. You need to have plans that address how the health information in every format will be preserved in event of a natural or man-made disaster, and how will you recover it? How will you get back up online? What will you do in the meantime? All those types of things. And then incident reports. You document occurrences that are inconsistent with the healthcare facility's routine patient care practices or operations with an incident report. And if you do it properly, it should not be discoverable. It should never be placed in or referred to in a patient record. Never, ever, because once you do that, you make it discoverable by the opposing attorney. It is protected by most states as privileged information. The court may allow it after hearing arguments by the plaintiff against privilege law or policy. But if it's kept privileged, usually it will not get dragged into court. So do not ever put an incident report in a medical record. Don't scan it in. And if you have somebody who refers to it, they need to modify their documentation appropriately to eliminate that. And they need to be counseled, educated to never do that again. Incident reports are outside of the record. They are never a part of the record. They're separate. Peer review, I mentioned that a little bit earlier. That involves physicians. Peer review is when you identify a case that was that had an unusual or negative outcome, and you want to look at the standard of care provided by the physician, or the surgery technique that was performed, or you're just looking at it to see what's going on here. Most records that go to peer review, they're reviewed by another physician in the organization, and usually it's kind of like, well, you know what, I would have handled it the same way as that doctor, and that's the end of it. Every now and again, you get a case that you think needs to go outside of the organization for external peer review to get someone who's a medical expert in that area to take a look and see what they say. If it comes back that, you know what, this really isn't standard of care, something different should have been done, then it goes to the medical staff, department chair, and the leadership of the medical staff to determine next steps. Sometimes they may say to a physician that they cannot perform a certain procedure until after they have had additional training. Or they may say that for your next 10 procedures, you need to have them proctored by a physician who's an expert in this field, or things like that. Or they may sanction the physician or censor the physician, or however you want to say, cite the physician and say, we've reviewed this. We don't believe that this was handled appropriately. The standard of care was XYZ. Instead, you did ABC, and we had this negative patient outcome. In the future, we need to see you follow the standard of care. So that's all peer review. Peer review is privileged. We talked about that. State laws may define the scope of peer review activities and provide privilege protecting records from litigation, meaning that they can't be discovered, or they aren't considered discoverable. These records do not generally meet the business records hearsay exception. They often contain inadmissible opinions and conclusions. They're considered hearsay. And minutes should reflect objective review, should not detail comments or discussion, should document actions taken, should have limited distribution. Just a lot of things you want to do to protect that information. I worked in medical staff services for a while and was involved with peer review. And even when I was in HIM, and also later when I was in quality management, there were times that I referred cases for peer review. I don't know that they always went, but if I saw something that brought up a concern or a red flag for me, I would just say you might want to consider sending this case for peer review. Protection of other medical documentation, other documentation that may be sought for discovery or admissibility, although a provider may wish to keep the information confidential, might be hospital committee records like Infection Control Committee, Quality Improvement Committee, Risk Management Committee. That's why you will see on a lot of those committee records, it will say privileged information in the header or footer, confidential privileged information. When it has that on there, it helps keep it confidential. Joint Commission survey results, hospital credentialing records, practitioner training manuals. Joint Commission survey results are really no longer confidential. In many ways, there are ways to find out what they are and what's going on with those. Hospitals like to keep those confidential, I'm sure, but state surveys definitely are not confidential. If they cite somebody for something, you can actually go out onto a website and see what they cited them for. Hospital credentialing records usually are privileged and held very close, but they can sometimes end up being discoverable. Practitioner training manuals, that's kind of a toss-up. All right, that's it for good old chapter 5 on evidence. Have a fabulous week, and when we come back to week 4, we will talk about tort law and corporations, contracts, and antitrust legal issues. Take care.